Well, first of all, I want to thank you all for being here, and I want to welcome you to Colorado Law for the fourth and final installment of this year's Silicon Flatirons Ethics Series. And I think, as many of you know, this is a dynamic exploration into the critical ethical dimensions shaping technology and business. Throughout this series, we've navigated compelling discussions on emerging technologies, artificial intelligence, entrepreneurship, startup enterprises, and complex business transactions. The Silicon Flatirons Center stands uniquely at the intersection of technology, innovation, and law. These three pillars are the reciprocally reinforcing legs of a triangle of thought leadership and insightful dialogue. This series has successfully united our very vibrant community of students, alumni, professors, local practitioners, employers, tech pioneers, and members of the general public alike. And together, we have fostered meaningful connections, exchanged expertise, and courageously, and I'm going to pause for a moment because we seem to be in a time when courage is particularly needed. We have courageously confronted the ethical challenges and the promising opportunities presented by modern technology. Today's event, like so many others here at the University of Colorado Law School, continues this tradition of excellence. And it offers an extraordinary opportunity to engage directly with an esteemed panel of experts actively shaping the ongoing conversations and the regulatory landscapes surrounding artificial intelligence and privacy. I don't have to tell you that these are some of the key issues of our times, and so I want you to prepare yourselves for a stimulating discussion that examines how collectively, together, we leverage our ethics and our core values as essential guideposts in navigating the future. Now, I could go on, as many of you who know me know, but I won't. I'm going to end by saying thank you so much for joining us in this very important conversation. We are so delighted to have you. And now I'm going to turn it over to Professor Melanie Kay, who is also the director of the Daniels Fund Ethics Initiative Collegiate Program at Colorado Law. And in that capacity, I have to say I've had the great opportunity over the last 4 years that I've worked here of spending a lot of good and valuable professional time with Professor Kay. And we are so lucky to have her. And so without further ado, I bring you Melanie Kay, who will tell you a bit more about her ethics programming and about the series. Once again, thank you so much.
Thank you, Dean Inniss, for that fantastic introduction, and welcome to all of you to our final event in the Silicon Flatirons Ethics Series. This series has been a fantastic opportunity to tease out and analyze critical ethical issues in our use and regulation of modern technology through conversations with some of the nation's most impressive and experienced thought leaders in the field. Today's event is no exception, and in a moment, I'll turn it over to Colorado Law student Maddie Castellano to introduce today's panelists. But first, I wanted to thank the Daniels Fund Ethics Initiative Collegiate Program for the partnership in developing this series and for supporting unique and innovative ethics programming at the law school for over the past decade. The Daniels Fund ethics principles of integrity, trust, accountability, transparency, fairness, respect, rule of law, and viability are key in untangling challenging ethical questions and are particularly relevant in tonight's topic. I'd also like to thank the amazing team here at Colorado Law for their efforts to make this series a success over the past year, including Michelle Logan with our Ethics Initiative team and the Silicon Flatirons team, including Brad Bernthal, Nate Mariotti, Sharon Sturgeon, Christine McCloskey, and Sarah Schnittgrund. With that, I'll introduce Maddie Castellano, the incoming president of Silicon Flatiron Student Group, to introduce our moderator and panelists.
Hi, everyone. My name is Maddie Castellano. I'm a current 1L here at Colorado Law, and I am the incoming president of Silicon Flatirons. I have the privilege of introducing our panel today. Our moderator for the evening is Vivek Krishnamurthy, an associate professor here at Colorado Law and the director of the Technology, Law, and Policy Clinic. Joining him will be Calli Schroeder, senior counsel and AI human rights program lead at the Electronic Privacy Information Center, also known as EPIC. She will open with a harms and risks-focused approach to privacy developments. Next, Kathleen McInerney is the founder of IG Strategies and will discuss the international perspective and geopolitical forces affecting AI privacy. Margot Kaminski is an associate professor at Colorado Law and is the director of the Privacy Initiative at Silicon Flatirons. She will discuss AI regulatory coverage and contours in the EU, focusing on information governance, privacy, and the freedom of expression. With them is Stevie DeGroff, the first Assistant Attorney General for the Technology and Privacy Protection Unit at the Colorado Department of Law. Stevie will review Colorado and state acts for AI privacy. Finally, Shelby Dolen is a Senior Associate at Husch Blackwell on the Data Privacy and AI team. She will discuss standards, best practices, operational realities, and ethics surrounding AI privacy. With that, please join me in welcoming our panelists.
Well, thank you, Maddie, for those wonderful introductions, and Dean Inniss, Professor K, for your words of welcome. I'm thrilled to be moderating this fantastic event with just a great lineup. And if I may build on the Dean's words about courage in this time, I'm going to utter a controversial word, diversity. And I love the fact about, that I'm the affirmative action person on this panel of experts. So may we continue to do that for many years to come. But without further ado, I'd like to invite Calli to kick us off with a really provocative presentation, I think, which is great. And just for the audience, the way we're going to run things tonight is we're going to have each panelists speak, deliver remarks for about 5 to 7 minutes, and then we'll have some discussion among the panelists on each person's remarks before turning it over to you for your questions, and then, of course, dessert. All right, Calli, there is a clicker, I believe. I want to use that. Like a stand. Yes. And the time is perfect. Thank you.
Should I steal the clicker and go back? Oh no, this is on. I'm very professional. It's very nice to speak with all of you. I'm going to start with I promise, short presentation about the focus that EPIC has when we're talking about AI. At EPIC, I lead the AI and human rights team. It's a very human-centric, human-focused approach to AI. We're looking at human impacts and how the conversation and development of technology affects people and how you can do it responsibly and with that in mind. So. Very quick intro is that we already mentioned, I do quite a bit at EPIC. I previously was at a law firm and I worked on compliance teams. I worked with companies that were trying to comply with international privacy laws. I was at the IAPP, the FTC, and I graduated from University of Colorado in 2016, which feels simultaneously like it was yesterday and 100 years ago. And then final note, everyone that talks about AI does come into it with some preconceived notions and some biases, and I think that we should be very transparent about that. I will transparently say I am the party pooper here. I do not like AI, and I'm very critical of it. So with my presentation, I want to be very honest that that's the standpoint I tend to come at things from. So one of the key points I want to raise is that in conversations about AI, frequently people will talk about it like because it's technology, it's neutral, because it doesn't have emotional biases, because it's uncompromised and it's based on pure facts and pure data. It's going to be neutral or at least more neutral than people are. This cannot possibly be true. Systems are made by people, and the way that they develop those systems, the way they train them, the way they program them, all reflects the individual programmer's biases, history, data, and the context that they know. You can address that in some ways by having diverse teams of programmers and developers so that you're addressing things from multiple perspectives and hopefully closing those gaps. You can absolutely consult with different people, technologists, ethicists, attorneys, people that work in human rights and other areas, but it's very hard to ever get to a system that is truly neutral and truly perfect in any way. AI is one of those that is a little even more concerning in that way, partly because there are some AI systems that continually train, develop, and adapt themselves, generative AI in particular. So with that, even with the input and the initial training, there may be ways that a system develops that you don't anticipate and you need to counteract and you need to constantly evaluate. The phases of ethical concern when you're looking at building an AI system and evaluating an AI system are all throughout the life cycle of that system. So initial concept, why am I building this AI system? What do I think it can do? What would I like it to achieve? In building it, you've got to look at who your team is, how they're constructing things, maintenance and updates. Those have to be very regular, particularly for systems that continue developing. Audits, really recommend outside external auditors who can be very honest with you and identify gaps that you may not see, because when you're very close to building something, we don't see all the problems. And then marketing, got to be honest about what your system does. We see a lot of AI marketing that makes really, really bold claims that are, it turns out, backed by nothing but hope. And then applications, you have to look at what areas are you anticipating this technology is going to go into? Are they highly sensitive areas? Are they things like housing and financing and criminal sentencing that can have really tangible effects on human lives? Meme, always a meme. So when we're looking at harms of AI, the harm potential is infinite because the way that AI can be applied in the world is infinite. That doesn't mean that every application is going to be harmful, but it does mean the potential is there, and we always have to be aware of that. So a list I put together of just off the top of my head some of the harms that we are already seeing happen in AI systems and applications. There is a lot of bias that is built into AI systems. In many cases, this can be through development, but in lots of cases, it's through training data, because if a system is trained on historic data that reflects the history and the biases of that history, you're going to see outputs that reflect that. So, tangible example, if you're looking at like a sentencing algorithm and it is trained on historic data, historically, our justice system has been very biased towards much worse sentencing for people of color. If you're training on historic data and it's spitting out predictions and outputs, it's going to reflect those biases. And it's not because the system is evil, it's because the system is reflecting the data that got put into it that did not get corrected. So it'll perpetuate that bias and perpetuate that system. We have misinformation and disinformation campaigns. We saw a lot of that in the election cycle. We continue to see quite a lot of that. There are a lot of AI-generated and spread conspiracy theories, images, videos, audio. There's data degradation. AI systems, particularly those that scrape data and put it back into their training data sets, are scraping information that AI generated, goes back into an AI system, keeps coming out, and the data continues to degrade from there. Scams, harassment, impersonation, blackmail, it's a very long list. EPIC focuses in particular on privacy, that's our specialty, and human rights. So in all of these conversations, we're trying to make sure that human impact and human rights are centered in the conversation. This can be really challenging because a lot of AI discussion is about potential, it is about hypotheticals, it's about hope, it's about what people want AI systems to do. And I think it is good for people to be aspirational and look for ways to improve the world. I am not trying to stop people from building good new things. What we are trying to do is say you cannot focus potential on how successful this is going to be or how it's going to revolutionize things and ignore already happening harms. A lot of the potential that from AI systems is yet to be fully revealed. It's in some cases hypothetical. It's in some cases we won't know if it will reach its potential for many years. But the AI systems that are already implemented have impacts that you can see today. We don't have to wait to see them. We're seeing them, and in many cases, they're pretty harmful. So, with all of that, I'll turn it over to others for how the laws are addressing these issues, but these are the things that we pay the most attention to, try to combat, and try to remind people in conversations that you can be very excited. We want people to be innovative. We want people to keep pushing for improvements, but in all of those conversations, you have to focus on how does this affect people today and in the future.
Calli, thank you so much for kicking us off with that dose of reality. My gosh. Okay, so panelists, any questions? Or I can kick us off if you'd like with, you presented a picture of a lot of harm, right? Yeah. But you also did concede that you're not against useful things. So given where we are with the law, and we're going to talk a lot more about that, what would you suggest if we are to use these tools? What are the steps that we could take, or if you're at Epic using AI, to alleviate some of those harms?
So some of it is a cost-benefit analysis where you have to look at what is this AI? What is it purporting to do? Are we sure it can actually do the things it's advertising better than the systems that we have? So first, it's just, is this going to be as useful as we think? You also have to look at what are the impacts of this, and are they offset by the benefits? At Epic, there's a lot of, like, the question also looks at what would Epic consider when we're looking at adopting AI. It's very unlikely Epic would ever adopt an AI system for a few reasons. One is we're a nonprofit, and a lot of people that I work with are very activist in a lot of ways. And that includes in ways that aren't privacy specific. I have colleagues that are extremely conscious and active in environmental protection groups. We haven't seen a lot of AI systems that come without pretty significant environmental harms. I have colleagues that are very active in labor groups. We haven't seen a lot of, we've seen some issues with AI systems that are displacing people's jobs and reducing workforce options, and we wouldn't want to be supporting that system. So until we can see AI that can demonstrate that it doesn't have those harms and we wouldn't be contributing to those harms, we wouldn't adopt that. Now, I recognize Epic is a very unique group. Most businesses are not in the position to just wholesale say, we're not going to use AI. I don't think that's realistic for people. But when you're doing evaluations, I think what you have to look at is, does this do the job better? What are the negatives here? Are there ways we can alleviate those negatives? And are we open to having criticism and people come in and push back on these things? And in general, some of it comes back to what we were doing when I was at law firms with product fitness, compliance, that sort of thing. There's a lot of really fundamental basic checks you do anytime you're contracting with a third-party company, and that includes looking at, like, what data are they going to be taking? How are they going to be used? What kind of contracts do we have in place? Who has liability if this goes wrong? What are the accuracy checks on this? And is that all verified throughout the system? So if you're using kind of the fundamentals of engaging with a third party, you're going to be addressing a lot of those issues.
Mm-hmm. Great. Yeah, Margot.
Excuse me. Thank you, Calli, for that presentation. So I'm going to ask a question by way of framing the panel a little bit. So what is an AI problem and what's a data privacy problem?
Mm-hmm.
Right? Epic is a data privacy organization that's also doing AI policy work. And one example I want to give to you is facial recognition. What aspects of potential harms or benefits of facial recognition software are things you would characterize as data privacy issues, and which ones are things you would characterize as AI policy issues?
It's a really good question, and I wish I had a more concrete answer. But as far as we've engaged with it, in many situations, I don't see a way to disentangle data policy from AI, partly because of the way these systems are built, partly because of how they're applied. I think you really have to evaluate all of the data issues as you're evaluating an AI system. And some of that is in the training data, some of that is in the application, some of that is in the inputs. But like for the facial recognition example, facial recognition is biometrics. That's personal information. There's no way to make that not personal information. And usually that's being compared against a big database of faces, and that's all personal information of different people. And it's very hard to separate the two. I think there are some distinctions. So with AI, you can look at how a particular AI is constructed. That may not necessarily implicate data on its face. It probably will in application because most of those systems are going to take in a lot of data in their training and in their outputs. Their outputs may include more personal information. But there are like technical construction questions of AI and how an AI is built that I think you can separate out of it. One of the real challenges is that Epic is very loud about pushing for a US federal privacy law. Still haven't got there, maybe before I die. But if we had enforceable privacy law, that does address quite a few of the issues that we have with AI. Not all of them, but quite a few. If people have rights in their information, if you can enforce, hey, I don't want my information in your training data or in your system, you have to remove that, you have to retrain. It is structurally challenging for some of these systems, but having those laws in place and having those rights and protections in place would help address many of the ethical questions.
Yeah, Stevie, please.
Significantly heavier microphone than I thought it was. I heard myself. So I kind of want to go back to a slight pivot on the first question that was asked and thinking like we're going to talk a lot, I know this half of the table, especially about the laws that could potentially protect consumers from some of the harms you talked about. But I'm interested in what an average consumer today could do, if anything.
We have this conversation a lot, partly because while there is a large community of AI enthusiasts and people that are very excited about the potential of AI, there is at least equally, maybe more, a very large chunk of the population that actively dislikes AI or is at best neutral about it. We've had a lot of conversations, gone through a lot of polls, talked with a lot of people about their interactions. And granted, I need to preface all of this, AI is a catch-all term. It can mean anything from like the predictive text on your text messaging to extremely advanced generative AI systems. So it's not super precise for us to just keep saying AI as if all levels of AI have the same risk and harm thresholds. But generally when I'm talking about the higher level, higher risk areas, just as a preface. In general, I think one of the hard things is that with AI systems, with AI development, a lot of the pushback is a lack of control and feeling a kind of helplessness, like they don't get a choice and they don't get a say in things. And some of that is in how AI is developed, some of it is in how it is applied. There's a lot of people that really don't like that Google automatically has that little AI thing that pops up when you use a search now, and there's not really a way to turn it off. The lack of choice is a real concern that a lot of people have. So when it comes to individual actions you can take on AI, of course, you can choose not to use AI systems. You know, I can make the stance that I don't use ChatGPT or something. But that doesn't necessarily change that there will be many services I have to engage with that AI is already fundamentally in. And the company gets to choose that, and I don't really have a lot of options there. So in talking with people about engaging with AI, you make some individual choices, but I think we have to acknowledge that the power dynamics of this mean that the companies have way more say, get way more choices, and ultimately it has to be enforcement on the companies. This can't be something that we leave to individual choice, because not only do people not really have the individual choice, it's so omnipresent in so many systems now that even if they had options, it would be a full-time job to try and take yourself out of AI systems. And that's not really something reasonable to expect from people.
All right, well, I think we're off to a great start.
Thank you, Calli, for kicking us off, and Vivek for the intro. I'll give you a quick introduction of who I am. I'm also a CU buff. I'm not going to say what year I graduated in. It was before her. After that, I went on and got my master's in international peace and human rights from American University in DC, which led me down a path unpredictably into international trade lobbying, which is a very hot topic now, but a topic for a different discussion, and technology policymaking. So I worked in Yahoo and in eBay, mostly on the international side. At Yahoo, I was part of the team that was on the GDPR implementation. I also worked very closely with the teams in Brazil and the Brazil Privacy Bill. We also worked on the Brazil Internet Bill of Rights for users. From there, I went over to eBay, where I led international for StubHub. If you think AI is controversial, try secondary ticket marketplaces, very controversial. And my most recent technology full-time job before I started consulting was at a Latin American company called Rappi, where I led the privacy team, the trust and safety team, and the government relations and communications teams. So that has led me here today, where now I do a lot of consulting also around AI and international applications of AI bills and regulations, which is what I'm going to talk about today. So I'm going to take us from Calli's very good, very precise overview of the harms to a 30,000-foot level of what is it that we're looking for to solve when we're thinking about AI regulations. Following your inspiration, I'm going to state my biases. I am an optimist. I believe in the power of social norms, and I do believe that there's a potential for governments to move in and create regulations that actually have the power to transform the conversations we're having today into how can we harness an amazing potential for an overall social good. And when we do think about AI regulation, under that bias, I think certainly one of the biggest challenges that we face right now is creating a regulatory regime that will stand the test of time. And one of the interesting things about this AI debate, which is different from the debates that we've had over time in regulation of big sectors, is that our time frame has moved from decades to months, right? And that's a big challenge for governments who are looking at how can you create regulation that's going to be relevant for into the future. Beyond that limitation, there's also a magnified and outsized impact of the international scope that AI has that requires a level of coordination and cooperation that we really have never before achieved. So how is it that we can create regulations that will be enforceable and also harmonized to a degree across multiple different geographies and cultures? On top of that, we're also facing the shadows of the past. Specifically, when I'm saying that, I'm talking about the history left behind by the big technology giants that color and influence the way that government, civil society activists, and nations think about regulating technologies, any technology, but especially transformational technologies. So in general, I do think that the framework of thinking about harms is a good way to start, right? And I think when governments, and we'll hear more from experts more in this area, but when governments think about how they're going to regulate something like AI, they think about it as harms and opportunities, right? And your context and your history determines whether or not you think about something as a harm versus an opportunity. And depending on that context, a harm can flip to an opportunity can flip to a harm. Let me give you an example. So in the case of the EU or a Brazilian context, where we do have some overarching AI regulation that's either already passed or being discussed, classifying a human based on your inherent traits or your protected classes, or tracking a human for a day using biometrics or a video surveillance would be considered a harm. But if you're an authoritarian regime or a dictatorship, this could be considered an opportunity. So your context very much determines how you think about what are your benefits as a state, or what are the potential harms that you're going to be looking at regulating, right? So sometimes the same use case for something that can be considered a harm could be considered for a security-focused regime a benefit. So the first big question this brings to us is, if we want an international regime that allows for enforcement, cross-border cooperation, predictability, how can this be done with such different state goals? I don't have the answer, but it's a big question that is going to impact whether or not the AI regulation that we get passed is actually enforceable. The next big question is, and Calli alluded to this, is it more important to protect your commercial or economic national interests or human rights? And again, your context matters. So if you're operating in an area which has had gross human rights abuses, such as Brazil or in the EU, that changes the way that you think about applying rules and thinking about the role of government in helping to enforce and define human rights. So we've done a lot of analysis over the EU. I'm running out of time, so I'm going to jump straight to my discussion around Brazil. Because I think in this particular case is one place where we can really look at how these big questions are coming into a real life debate for how AI can be governed at a national level. And in Brazil, one of the interesting things that's happening in that discussion is that the Brazilian government is concerned about protecting citizens not only from the interests of private companies, but also from the government itself, right? Because they do have this history of human rights abuses and a fear that their democracy is at risk. So how is it that you can regulate AI to protect your nation and your state from the potential harms of those systems? And in that process, actually create new human rights, redefine the way that we think about human rights. And so in that, I think there's 5 key things I'm just going to go through really quickly about what's interesting and global about the Brazilian regulatory debate. The first is the approach is based on the EU. It's a tiered approach. There's 3 tiers. And in that political context, there is a strong consensus around the need to regulate. The second is a longstanding concern about the amount of power tech companies, particularly social media companies, have in that context. Which leads us to our third point, which is the political economy debate, which is if you have political consensus around getting a particular piece of regulation passed, how can the politics that are dominating the conversation kind of move that debate to start moving the regulation to regulate something that's actually outside of the scope of what you should be talking about, in this case, social media, which is a big component of the debate in Brazil. So how is it that AI bills and concern about AI can be harnessed to achieve other goals on tech regulation? And you might have a feeling that that's a good thing, you might have a feeling that's a bad thing, but it's definitely a piece of that debate. The fourth is, what is the best approach to either regulate or enforce? Should we as nations think about breaking our regulation into a sector-based approach, or should we have a centralized approach so that you have one enforcement body? It doesn't matter if you're oil and gas or if you are a pharmaceutical company. If you're using AI, your AI is going to be regulated and enforced by the same body, or is it going to be broken and your own regulatory enforcer will be in charge of enforcing AI rules? And then the last piece is copyright. So how can models be developed in ways that bring social good and innovation fairly and without limits? And how is it that both content creators and artists, as well as AI developers and users, can all benefit? Very quick overview.
Thank you, Kathleen, for injecting some optimism into the conversation. But then, also pointing out to the serious challenges. Does anyone want to jump in with a question for Kathleen, or I could use my prerogative? You're smiling.
Your prerogative.
Oh, all right. Well, here, please, Calli.
So I really love the focus on different application of laws in Brazil versus in the EU. Brazil has a really interesting history of kind of wholesale taking some laws from the EU and then adapting it for their own government structure and cultural context. And in that, I wonder, are you seeing a lot of real debate within Brazil about how to apply this, or does there seem to be consensus on the goals and differences on how to achieve those?
I think there is definitely an intention or a tendency in Brazil to wholesale take rules from the EU, much to the chagrin of the US government, which would like to be the role model, but often isn't. And you definitely see that from the GDPR perspective, right? So their approach to data privacy protections is very much in line with the EU. Their approach to AI regulation is very much in line with the EU. But it is more what we call tropicalized, right? So it's a way of thinking about how does the law fit into the different context that is Brazil. And one of the things that in my notes, but I don't have time to say, is that Brazilians are a very proud nation with a long history and a unique culture, right? And a unique language. And that has led to, number one, a very strong emphasis on maintaining their identity through their laws and regulations and through their approach to how international companies can operate and build companies in Brazil, right? And then the second is this insistence that they are a global world player, and that they do have the ability to change the way the world thinks about big things. And they have a really strong track record of changing the way pharmaceutical companies operate, of changing the way technology companies operate, of forcing big companies to think about cultures that are non-English speaking. What does that mean? And so yes, they do look to EU for the basis of how they would apply or how they would think about writing the rules. But in terms of the application, they're very sensitive to how is it that this is actually going to benefit Brazil and Brazilians in a way that the EU doesn't really have because of the broadness of that scope, right?
Yeah, Margot.
I want to talk about transplants for a second, or exports. So we haven't talked about what the law is. I know we're still teeing that up. Talked about so far are what are potential harms, and then what interests do nations have in enacting anything to regulate these harms. And so I wanted to ask for Kathleen to weigh in a little bit on some past experiences that I heard echoed in your description of your job experiences. So when I think about global contagion of laws or transplanting of laws or harmonizing of laws, in the tech context, I think of like a couple of prime examples of this. The first is intellectual property law, where you have an international mechanism that starts as being softer international law in the United Nations. And then you have the big IP producing states like the United States saying, and I'm really gross, these are gross summaries of this, broad stroke summaries, but big IP exporting states like the United States saying, wait a second, this isn't like pushing the law in the direction that's really maximizing the benefit to our homegrown companies. And it would be really great if we didn't have IP piracy in all of these other countries around the world. And so they move it into the trade system, which has real enforcement mechanisms behind it. And that really does a serious amount of work towards harmonizing at least digital copyright law towards the US version of that law. Then you have the EU talking about data privacy, and very deliberately, which it did not do with the AI Act, which is really interesting, in its data privacy regime, building in a forced export measure called adequacy, where if the European Union is going to have any companies in the EU transfer any data to a third-party country, that country has to be deemed adequate by Europe. And the one remarkable exception to this is the United States, which has its own mechanism. We can talk about that for a long time. But what I'm curious, and then I have a last version of this, which I think is more what's playing out in the AI context. I'm curious about your thoughts on this, right? Is this like IP? Is this like data privacy? Or is this option C, which is, this seems to me to be very much a game of standard setting, right? There's a lot of soft law in the AI space. There are a gazillion different standards on how to do ethical AI that have developed in various institutions. And a lot of the laws, including the AI Act at the EU, basically center themselves around standards that are being developed in international standard setting organizations. So what is that? Like, what export mechanism is that? And do you agree with me that this looks like something else in terms of how harmonization is happening?
I think that's a really interesting question. And I think we're on the early side, right? Because I also think if you think about where we started with privacy law, there were competing models, right? And it just happened that GDPR had the adequacy that forced that model to become, in my opinion, more dominant than some of the others that were also being very strongly advocated by large groups of people, right? And I think we're in the early stages of seeing how AI regulation will play out in the world stage. And I think there's it's interesting that you bring up IP, right? Because I do think in IP, we have some really, and copyright, we have some really interesting pressures on the lawmakers that if we could solve them through a consensus around how is it that artists or content creators can choose to opt in or opt out of training data, models, and if they choose to opt in, how is it that they get fairly compensated for that? How do you know that they get compensated for that? And the opt-out models that we've had in privacy and tracking have failed, right? And so this is, I think, one of the really interesting challenges that's being tackled in this debate right now is, can you develop a system that will recognize the rights of copyright holders or of intellectual property owners within an AI system that then can be globally recognized? Like, can you take that one small piece and find consensus around that piece that would bring the groups together, and then that would be like an exporting model, I think, of those AI bills, because then you'd bring together two huge groups of like interested parties around AI regulation in a way that could end up seeing cascading effects in AI.
Well, Margot, I'm going to turn it over to you to expand on this really interesting set of points that you've started to explore in conversation with Kathleen. Do you want to come up to the podium?
I do not want to come up to the
Okay, that's fine. She gets to choose.
Nothing personal. I was teaching class this morning for several hours. I'm going to choose to sit. So I am basing this presentation on a talk I gave a couple of months ago. And at that talk, I mentioned how I was basically summarizing 144 pages of law in 1 hour, and that was really unfair. And now I'm going to summarize 144 pages of law in 6 minutes. So I'll give you the big contours of where the rubber hits the road in the EU AI Act, and then I'm open to discussion and questions, including with all of you and my fellow panelists. So the EU AI Act, which went into, which was enacted last spring, is a very odd law. And I say this as somebody who has a background in data privacy. So data privacy in the European Union has roots in different countries' laws going back to the 1970s. And the EU AI Act was written in on an incredibly fast timeline compared to privacy law. It never went through the usual journey that EU law goes through, where it starts as being in law in some member states, and then it becomes a directive, which is like it's like a soft law treaty where they require every member state to enact it, but every member state implements it slightly differently. It just went straight to like massive regulation on the EU level. And there's lots of interesting sort of political guesses about why this happened. But what it actually is, it doesn't replace European data privacy law. So the GDPR is still there. The GDPR, General Data Protection Regulation, still has specific provisions that do apply to AI, specifically to things like facial recognition, to processing of sensitive data, to the use of systems that make automated decisions about people, which sounds an awful lot like a lot of AI systems. So the EU AI Act is gap filling somewhere else, right? It overlaps with, but doesn't replace the GDPR. And that itself sort of raises interesting questions. So what is this thing? I'm going to describe this really briefly and then come back and give you more detail. At its core, it's risk regulation. What does that mean? It asks the developers of AI systems to take it on themselves to test, check their data, double check to see where they think they might be deployed, and look at basically Calli's list of possible harms and try to lessen the harms as much as possible as they're developing the system. This is modeled on the scaffolding of European product safety law. So there's a set of different laws or regulations in the EU that govern things like how safe your elevator is, or safety in certain kinds of cars or in boats. And the same system, the same scaffolding of those laws is now being used to govern the circulation of AI systems in the European Union. What this means is that basically companies that create AI will conduct all this risk regulation, self-certify that they've done that work. They put a little stamp on their product, don't ask how, that says CE, which is basically like cleared for distribution in the European Union. and then they can use it in the EU, because remember, this is all about trade. The enforcement mechanisms basically look at it and say, okay, did you in fact mitigate your harms, which they only know about after the fact when something goes wrong? Or do we see some sort of big event happen and we might ask you to do an AI recall of your system? So very much like the elevators or the boats. I'm going to get into some more detail. This is not all that the AI Act contains, and that's because it was enacted in a crucial period of time. The AI Act was built around a particular mental model of what AI systems are, and that is an old mental model. It is built around the idea, I'll skip my notes to make sure I have this, that systems are basically built for a particular purpose and then used for a particular purpose. So if you look at, I'll get to what these are in a second, but you look at the category of high-risk AI in the AI Act, and it includes things like the use of AI in education, the use of AI in employment, the use of AI by law enforcement, the use of AI by judges. What you notice in that is that that nowhere says general purpose AI systems. ChatGPT was released during the enactment of this law. So within its scaffolding of treating AI like elevators, right, it's got these little pop-up moments where it focuses on trying to regulate general purpose AI. Right? In addition, you see other, like after the fact added in moments that look at things like requiring an AI chatbot to disclose to people that it is in fact artificial intelligence, or requiring the watermarking of information that's created by content that's created by AI systems so that you know that it was generated by AI systems as a viewer. So the thing is all like a jigsaw puzzle that was put together in real time and is 144 pages long. Now, to get to the core of it and what is actually in it. So you've got the core of it built around what are referred to as risk tiers or risk buckets. And that divides the kind of AI that's used in for specific purposes into 3 different categories of uses. And you'll hear a lot of this reverberating with what Calli laid out as possible harms. So use category number 1 is unacceptably risky systems. Unacceptably risky systems. That is a list that is actually publicly available, and that it can be amended, but it's a not so easy process to amend it. And unacceptably risky systems are banned in the European Union. One example of this is the use of AI systems or the use of facial recognition systems to conduct facial recognition surveillance by law enforcement in real time in a public place, with the idea being that that sort of surveillance in a non-authoritarian state would always impermissibly impinge upon expressive freedoms. There are other examples as well. But so that category A, that's the red light and the traffic light, those systems are banned. This is already a big deal to do that, right? We've had some facial recognition bans in the United States, but by and large, there are not bans on the use of AI systems in other countries. So normatively, it's a big deal that the EU did this with regards to a certain number of systems. Second tier, the yellow light and the stoplight, is high-risk AI. And that's the bulk of the 144 pages. So high-risk AI systems, which basically are systems that the EU has decided are risky, but not too risky, but also not risky. And there's a list, it's in Annex 3. It can be updated by the European Commission. Those are regulated predominantly through this elevator framework. Right? So it requires the producers of providers of AI systems to do a whole bunch of things, which includes, checking their data provenance, running tests on their systems, mitigating risk, et cetera. And then finally, the green light of the traffic light of risk buckets is low-risk AI systems, which don't really have to do anything at all. So if you're the provider of a low-risk AI system, which is anything that's not named in Annex 3 or as part of unacceptably risky AIs, then you can voluntarily adopt the stuff that they do to govern high-risk systems. All right, so a few comments on this. Again, I think that the move of actually banning some systems is a big normative move because it forces other countries to think about where is the line that we draw, right? You may not agree with exactly what the EU's line is. I'll give you another couple of examples of it. So the use of AI for social scoring is banned. The use of AI for predicting the risk of committing a criminal offense, which is the Minority Report example, that's banned. The use of AI to infer your feelings at work or at school is banned. Okay, you laugh, but apparently our recruiting software at University of Colorado does this. Okay, so then if we get to the high-risk systems, then we see things like the use of AI in education and employment, access to essential private services, public services, law enforcement use of AI, judicial use of AI. That's all stuff that's allowed but regulated. So that again is an important normative move. Finally, to close out with some criticisms, it's weird to regulate AI systems like you regulate elevators, especially if the risks that you're trying to mitigate are not risks to safety, right? Some AI systems impact safety. Not all AI systems create harms that sound in safety, as we saw from Calli's list. So if you're trying to regulate AI systems to reduce risks to fundamental human rights, which is part of this act, and those fundamental rights include individual rights like rights of free speech, rights of assembly, rights to privacy, then the delegated risk regulation approach is a pretty weird fit. There are no individual rights, bar one, I could talk about it later, in the EU AI Act. It is all just delegation to companies to figure out how to fix things. All right, so I think that's enough for me, and I'm happy to open up to discussions.
Thank you, Margot. That was remarkable. A tour d'horizon, as they say, in at least one European country or a couple. Questions, and we're a little behind time, but that was excellent. I wanted you to be able to set that up for us because it's going to be so crucial to what we discuss next about what's happening on this side of the Atlantic.
Well, it might not
please.
be a quick question.
Oh gosh, here we go.
No, I'm sorry.
Remember,
But-
dessert is after. So just...
True. Well, I'm going to touch on U.S. state AI laws later, and right now we're seeing like the approach of industry-specific AI laws.
Yeah.
And so I hear your criticism on the EU AI Act, and I'm wondering if you think there is any way that we can have a type of AI law that does use some sort of categorization scheme, or if you think that that doesn't work and maybe our industry topic laws don't work as well. I'm curious.
No, I think this is a hugely interesting comment. I wrote this back down when Kathleen was talking also. So again, looking at data privacy as an example. Europe famously has omnibus data privacy law. That means data privacy rules that apply no matter what industry your technology is deployed in. The United States, by contrast, has sectoral data privacy laws to the extent we have data privacy laws at all. So we have a health data privacy law, which is actually not, doesn't even have the word privacy in its title. We have a children's privacy law. We have the Video Privacy Protection Act, which is still my favorite one to talk about. Does anybody know why that was enacted? Yes. Yeah, look that up. So like there's lots of things that we don't cover. So there's one of the fundamental questions here is how much does it make sense for us to go omnibus as the EU did in the AI Act versus sectoral for AI regulation? And I'm not going to provide a satisfying answer, but what I'm going to say is I think that a lot of that conversation, as in the data privacy context, is really a cover for a conversation about whether we do a precautionary principle-driven regulation or we do a harms-based version of regulation. Because we can provide examples today of harms in different sectors in the use of AI in the United States. And that can more readily, given our political context, drive us to regulation in specific sectors. And my question about it is whether the EU is onto something going omnibus, and also precautionary, or if it makes more sense and if we have the political will to ever get to an omnibus version of an AI law in the US.
Well, we can't get it with privacy.
Yeah.
So.
Yeah, that's right. Exactly.
Well, if there's any place that might be able to do that, it's Colorado. So I'm going to use that as my segue for Stevie to please. I know you have some slides.
I have a couple.
Yes, fantastic. So
welcome any opportunity to come join you guys, Silicon Flatirons. So I'm going to talk a little bit about state AI regulation. I really like a rebus puzzle, so the future is now. There you go. I think that the thing I kind of want to focus on, and I'll touch on Colorado, but to be totally transparent, there's what I'm anticipating are a lot of amendments to the Colorado AI law. And so going super deep on the specific stuff, it didn't feel like a great use of everyone's time in this room. But I do think what we can do is talk about the ongoing conversation around what regulators think about when we're thinking about regulating emerging technology and AI. This is a great opportunity for me to say my disclosure that I am here in my own personal capacity and not speaking on behalf of the Office of the Attorney General. But, you know, I think the thing that I think a lot about, I can say, is that a lot of this isn't new, right? And every time there's a new technology, there's this theory that we always need a new law. And I know the FTC has said this. You've probably heard this on a ton of other panels where there's laws that already apply to AI, right? If you know, Calli brought up, if you make a misrepresentation, if you lie about what your AI product can do, and then consumers buy it based on that, that's like a classic misrepresentation and an unfair and deceptive practice law. So we don't necessarily need new laws for that. But I do think there's a history in this country of creating laws that are specific and useful when new technology comes around. And the example that I heard many years ago that I hold with me today is murder has been around since the 10 Commandments, but we still have vehicular homicide. So there's a reason why sometimes you need safety standards or different regulations for a new technology, given the increased risks that are there. And so I think one of the things I really want to talk about, is it this way? There we go, is thinking about what are the ways that the laws and regulations for AI that we're seeing from the states are pulling from what we've already seen. And what are the ethical principles really underpinning all that as we're thinking about regulation? And so I'm not going to go deep into what all the laws are. There's a lot that's happening at the state level in this space. But I do think it's interesting, and I love talking about this coming after what Margot was saying, to think about the different ways that everyone's trying to attack this problem. So you've already seen in almost every single privacy law that is now in the 19 states that have them, regulation of automated decision-making and profiling. Consumers can opt out. That's AI regulation, and it's been going on and will continue in that context. You're hearing about what's happening in Colorado and other states considering similar regulations around algorithmic discrimination. And that's, I think, a really interesting intersection of the the point about context in different countries, the history that we have of discrimination in this country, the categories that we consider super risky for discrimination, looking at AI as a high risk use in those areas and kind of combining those two methodologies and then layering on consumer protection and then layering on product liability. So it's complicated, but that's kind of what that's doing. And then you've got a whole bunch of other stuff happening, right? We're regulating deepfakes. Colorado also passed a bill last year regulating the way deepfakes are used in elections. We're seeing increasingly states looking at deepfakes used in non-consensual sexual content. We're seeing a lot of regulation around transparency, watermarks, bots having to disclose who they are. Now we're seeing increasingly chatbot specific regulation. We're starting to see, thinking, okay, maybe instead of thinking about the end use, we think about the frontier the foundational model, or we think about those frontier models that are super risky. And so there's just a lot of ideas that are coming at this. To briefly touch on Colorado, because I assume people want to hear about this, but I can't say too much today. I will say that Colorado's law does fall into this anti-discrimination space. So it's not really while it is comprehensive, and a lot of the press likes to say that Colorado is the first state to have a comprehensive privacy law, it is still very narrowly focused on anti-discrimination. It's looking at high-risk uses of artificial intelligence for consequential decisions that, not surprisingly, map onto the history of things we have regulated from a discrimination standpoint in this country. And it's using a combination of some standards analysis similar to some of the things that you're seeing in the EU, as well as some consumer rights. So making sure that there's transparency, giving consumers an appeal right, different things like that. That again, it's trying to kind of come at this from two different angles in a very specific area of application of AI. So with that being said, there's been a lot of conversation about this bill. I think because we managed to pass it and Connecticut didn't, it's all been focused here in Colorado. So there's a lot of people that are very interested in it, which is kind of led to two things. One, our office did undertake a pre-rulemaking. Basically, we acknowledged that there was a high likelihood of amendments, but we wanted to make sure that we had an understanding of what elements of the law as written were confusing or were great. And so that is complete. All of those comments are now available online. You can read them. They're people, right? When I first started engaging in rulemaking in Colorado, it like restored my faith in democracy. Like people write really deep, thoughtful comments here. So there's really fantastic comments there. There also simultaneously was an artificial intelligence impact task force that the legislature run. So they have a website as well that's up here. There were lots of meetings there. It was a mix of people from academia. Margot was on it. Was on it with people from industry, people from civil society groups, all coming together to try to fix the law, for lack of a better term. There's been a lot of output from that group, which is why I anticipate we will see some amendments. I could not tell you with the crystal ball from my first slide what those will be. If you start to look at the outputs, there's a lovely document that I like that goes through, here are all the areas where we had differing opinions. If it's green, we've reached consensus. If it's yellow, it's an open question. And if it's red a standstill. I think there was like one green line. So I really don't know what's going to happen there, but I do think there will be changes. And so what I thought would be actually more interesting to think about is no matter how the Colorado bill changes or how any of that smorgasbord of ways that we regulate AI plays out across different states, what are the ethical considerations that we're thinking about as regulators, that we're talking to legislatures about in this space? And the two slides that are up here, or the two images that are up here, probably aren't new to some people in this room. They're based in privacy. And I posit they could just really kind of be transparent. That's the only reason I had slides, was so I could do that. Click. So just so you guys know. Very proud of that animation. So, you know, and actually I didn't know what this room was gonna look. Half of these things are also on this behind me, right? The ethics that drive this entire thing. And so these are principles that I think are really, really important for regulating emerging technology in a principled way. So thinking about fairness, right? At the core of consumer protection law, not even thinking about technology regulation, it's about fairness, and thinking about how can AI be deployed in a way and developed in a way that's fair and unbiased. And there's risks that you've heard today, there's opportunities in that space, but that's really the ethical consideration at the core that these different laws are trying to thread the needle to get at. Transparency, again, this is something that's really core to consumer protection and also is translating increasingly into the AI space, and we've seen in privacy and other technology regulation. Consumers need to be able to understand when AI is being used, how it's being used, at a minimum, right? I would also, again, personal comment, love for them to be able to correct things that are wrong when AI is used about them and appeal, if that's right. That, again, just feels very in line with how we've thought about consumer protection unrelated to AI. Makes sense in this space, especially, again, in these, we'll call them high-risk situations. I maybe don't really care like why you're sending me Nike shoes, but you know, there are times when I do care. Accountability. I think this one's really, really important. And I think this kind of ties back a little bit to Calli's first point, that this misconception that AI is good because it's unbiased and it's technology. And I think I'm a bit more of a pragmatist in some ways. I'm not really an optimist or negative on AI, but I think it's a tool like anything else, right? It can be great or it can be harmful. And so you have to be accountable for what your tool does. You can't just say like, oh, my AI made me do it. I didn't know, right? There's, in some circumstances, maybe it's not appropriate to have something be a black box. And when it is appropriate for it to be a black box, there's a ton of human decisions that go into deploying that or developing it. Is there human oversight, right? Is a human involved at any point in time? There's, should I even use it in this context, right? That's unrelated to the AI itself being unaccountable. The two last where I want to highlight are, accuracy and quality and integrity of the data that's used. I think that's really, really important when thinking about regulating AI. And there's a couple of different ways you can get at that. Maybe it's through consumer rights, making sure that it's accurate, or maybe it's through an affirmative obligation or standard on the data that's being used. And the last thing I think is minimization and limitation. And I think this kind of is, there's a lot of overlap with privacy and a lot of these. I think this is the one where there's probably the most overlap. with privacy in terms of minimizing the data that's being used into these systems. But also, I think thinking about who this is shared with, especially as you get more and more into generative AI. I, as a consumer, may feel like it's totally appropriate for AI to be used in one area of my life and engage in that way. But then if you're then taking that and reusing it in other areas, that could be problematic for a consumer. And so I'll close just by kind of saying, I think it's pretty obvious, but when we're thinking about privacy and AI and ethics and regulating all this new technology, it's not that any of this is brand new. These are all considerations that I can talk about for consumer protection, that I can talk about for privacy. We heard talking about copyright. These are things that I think intelligent people should be able to reason through as they're developing AI systems and as they're deploying AI systems, and not throw up their hands and say, oh, it's AI. There's no way you can regulate it. It's brand new. Because it's operating in a context where we have done this in the past. And at the end of the day, we're, again, I think as a state regulator thinking about consumer protection, I'm worried about protecting people. And I think sometimes technology can really aid that, but you have to do it intelligently and you have to do it thoughtfully. All right, I'm gonna go sit down and answer a bunch of questions that I may have to just. Thanks.
Really fantastic, and I love the cross out. I should do that more often. So I'm wondering if anyone has a quick question, or I'm half-minded to just have Shelby give us sort of the wrap up of the state of play across the country, and then maybe we sort of open it up inside us and then to our audience. Does that sound good? Yeah. Shelby, do you want to take it? Yeah, perfect.
Shelby Dolen, a senior associate at Husch Blackwell. I am actually a 2020 Colorado law buff, so one of the first pandemic graduates. Good times. So happy to be back. But without further ado, I am going to start with U.S. regulatory status. We've been talking about and leading up to what are the AI laws looking like here in the U.S. So I want to start by looking at 2024. If you can see the map that we have up here, the states in black are the ones that proposed AI legislation, but were not able to get that legislation enacted. The handful of states that were successful are the ones highlighted here in gold. As we've been discussing, and as Stevie noted, Colorado was one of those states. So just talking about what was passed in 2024, we saw Colorado pass the first algorithmic discrimination law that broadly covers deployers and developers of high-risk processing AI, whereas the other states passed laws that were actually much more narrow. So California and Utah both passed laws that required certain types of disclosures when AI is being provided to users. Along the same line of disclosure requirements, California also passed this Transparency Act that actually requires certain types of developers to explain what data sets are used to train the AI model. Virginia and California also passed health-specific AI laws. And then lastly, we saw Illinois, Maryland, and New York pass employment AI laws that really focus on using AI through the hiring process. Okay, so that was 2024. Let's jump right into right now. In 2025, we are seeing even more bills introduced based on our tracking as of this past weekend. And yes, that is weekly tracking. There are 479 bills that have been introduced to date in the US. 45 states have filed those AI bills, and we now have 10 that have actually been enacted. And what's funny is 7 of those were enacted last week. I had to update my slides. So this is a quickly moving space, similar to what we saw in data privacy, where states are kind of taking it into their own hands. So, oh no, I had a really cool pie chart. It's missing. But although this is an overwhelming amount of bills, the types of bills lawmakers have filed have varied greatly. To date, we actually grouped those bills into 28 different topics. You guys, my pie chart was really cool. I'll have to figure out how to get that to you guys. But lawmakers across the country are concerned about AI in many different areas, but we've seen a large amount of those AI bills be in the healthcare space. Not only how medical professionals are using AI, but also how AI is used in insurance decisions. Another dominant trend is regulating the use of AI in elections and in the regulation of pricing decisions. So it's important to keep in mind that while we are kind of grouping these bills into one category like healthcare, they really vary significantly. So that's important to keep in mind. And although we are seeing many bills introduced, like I said, 479, we only have 10 across the finish line with the legislative session, I would say about halfway through. So, we'll see if any other laws get across that finish line. Just last week, we actually saw the governor of Virginia veto a law covering algorithmic discrimination that made it to their desk. And that would have been the second law behind Colorado, but it was vetoed. So even if it gets all the way through the legislature, that can still happen. And along the same lines, even if the laws have been passed, we're seeing these laws go through the amendment process or rulemaking process. Not just the Colorado AI Act, but Utah's disclosure law actually just went through amendments. Okay, so let's switch over to norms, standards, best practices, and ethics. I think a lot of us have covered this today, but what I am bringing is kind of my experience with my clients. Almost all of my clients are either developing AI, deploying AI, or using AI at this point, which is why I'm not only a data privacy attorney, I'm now an AI attorney. So that's the experience that I'm bringing here today. Okay, so I want to think about it through the different parties that I just mentioned, developers, deployers, and users. So starting with developers and deployers, the most important piece is, do they have internal policies and procedures in place? From a developer perspective, these policies and procedures should provide a baseline requiring developers to consider the types of models that they want to deploy, what is the user base that they're considering, do they want to build their model on top of another public model? So those are all considerations. And I think based on the answers to those questions, that can lead to some ethical concerns. A huge issue that I am seeing is the lack of testing in the AI space. How accurate is the model that you are developing? I'm afraid some of these developers and deployers say, well, I don't know, but it's a great product. Let's get it out there on the market. Calli, I know that probably gives you a lot of stress. But even if you don't have a legal obligation to test your AI, don't you have the ethical obligation to consider whether it is accurate? And not only to consider whether it's accurate, but to be transparent to your users about whether and how much that AI model is accurate. So going hand in hand with testing is the use of training data. What training data are you using? Are you using a public model? Have you done your due diligence on that data that you're using? And then again, like I kind of said, another major consideration is whether you're going to design a public versus a private model. Do you want this to be available to the masses? Because that might bring in some more ethical considerations. Or is this going to be for a smaller group? So now as users, what should we be considering with AI? An interesting question that I get asked pretty frequently as an attorney is, do I have a duty to use AI if I can save my clients money by using it? I don't have an answer for that, but I've been asked that quite a bit. And not only from an attorney point of view, but anyone where time saves a person money. The healthcare industry, the financial industry, I think that's a question that we have to consider. But again, is that AI actually being accurate and useful in helping us provide a better service to our clients? The biggest step we are also tackling with our clients is a review process and an internal risk assessment. A review process obviously is something that you want to have in place so that your employees can understand, hey, what AI tools can I use? Do you have an approved list? Do you have an unapproved list? If it's not approved, do you have a process set up where it can be approved? We know employees are really excited to use AI, but let's make sure that they're staying in compliance with all of their duties as an employee under a company. And then risk assessments. This is actually something that we see in the data privacy landscape, where data privacy laws, such as the Colorado privacy law, actually requires you to conduct a risk assessment for any high processing activity, such as certain types of profiling. Lots of AI is used for profiling, which means if you're subject to those privacy laws, you're going to have to create a risk assessment. And again, if you're not legally required to do that, is this a good step? Is this going to help you approve an AI product in a better and more efficient way? So then I'm just going to jump to kind of the 3 ethical concerns that I see pop up a lot. And we've talked about them all tonight, so I'm going to wrap it up so that we can stay on time. But privacy and surveillance. Are you inputting personal data or confidential information or just company information into an AI product? And, right now I think a lot of these public models say, we're not going to use your data for training. We won't do that. Okay, well, if you're not using it for training, are you using it for any other purposes? Because that is some tricky language there. And also, many of those companies can update their terms at any time. So maybe they say, we're not going to use your data to train our models right now, but who knows what will happen in a couple months. And then bias and discrimination, we have absolutely touched on. And human review. Will adding a piece of human review to this process help with bias and discrimination? Or is that just the product of your AI model? What needs to be done there? So that's it. Thanks, everyone.
Thanks so much, Shelby. Does anyone on the panel have a quick question, or should we open it up to our audience? Yes, pardon me? Okay, let's open it up. So we are excited to hear your questions. And we have a tradition at Silicon Flatirons known as the Wiser Rule in honor of Shelby's boss. Oh, so Shelby's boss, sorry. Stevie's boss. Maybe that's a Freudian slip. Or a prediction that was not validated by an AI model. Anyhow, we invite a student, broadly defined, to ask the first question. And since we do have, because we're right after this, I'm going to ask you to keep your questions in the form of a question and quick, so we get lots of people in the queue. And we have a couple folks with microphones, so raise those hands nice and high, and don't be shy. Over there. Oh,
Wait, not a student, so
we're gonna give it the good old college try, as they say. Any student voices who want to come in? There we go.
I could ask. Oh, wait, we haven't.
Perfect.
Hello. I'm curious, I don't know if this applies to everybody, but in terms of data privacy and security, because AI is so new, how did that change the field? Like now is data privacy and security kind of just focused on AI, or what did that kind of look like in the last few years?
I mean, I think Stevie's slide where she took the data privacy principles and just covered them over and said AI principles kind of gives you the answer. So this is a battle of the experts going on right now, not so behind the scenes, which is that most people who have been in data privacy for a long time are like, this is a data privacy conversation. For people who have not been in data privacy for a long time, they might label it as a copyright conversation or a electoral speech and disinformation conversation, or as a conversation about intermediary liability and how much platforms should be on the hook for these things. So it really depends on your perspective. I'd say a lot of the conversations we have about AI that are about data governance, which is like, where did you get the data from? What's in it? What are you doing to keep it secure? Really do sound in data privacy, with the caveat that some of that stuff is data that's not technically personal data under these laws. So if you anonymize personal data such that it cannot be de-anonymized, most of these data privacy laws won't apply. But a lot of the principles that Stevie provided are still things we probably should be thinking about as core values in trying to regulate these systems.
Okay, one super quick addition to that. is that I completely agree with Margot that it's a matter of perspective. Data is definitely involved, but so are all of these other legal areas. But there is one thing that is really interesting with AI, which is that it brings up a lot of data security, data privacy, data governance questions at a speed, scope, and scale that is so heightened from what we saw before. And some of that comes with making things that we previously wouldn't have considered necessarily personal information. Suddenly it becomes personal information because you're able to draw from hundreds of sources and you're able to combine that information. You're able to draw inferences that aren't specifically stated in the information, but you can pull them in ways that are much more revealing than we've predicted before. So from specifically the data provenance protection side of things, there are a lot of existing principles that carry over and they're just kind of supercharged.
All right, we have a few questions here. Can we get the mic? Oh, you have the microphone already.
Yeah, I'll try to be brief about this, but one thing that Shelby's slides triggered a thought is states around the US can't even agree on textbook material and the accuracy of textbook material. So when you're asking someone to be the arbiter of truth for a training in an AI model and say that is the gold standard, we're asking AI and you all to create laws for a situation where the humans don't even agree. So what do we do with that, I guess?
I mean, so I can't make humans agree. I can't even make my parents agree because they're divorced. But I think that really fun. No, so I think two things. One, I think part of what you're seeing, if you are so inclined to go to dig into all the different laws that Shelby laid out for us today, is the standard. It's really about standard setting more so than saying it has to be done this way. It's saying you have to have tested, and like you can't just launch it without testing to see if it's accurate or unbiased. Did you do a risk assessment? So it's a little bit, I think people they may not agree on where the ball has to land, but they're at least agreeing on the lanes that you're in. I think the other thing that I'll just point out is, state AG's offices actually get along pretty well. I have colleagues in states all across the country that I partner with on privacy work, on broader consumer protection work. Our offices partner on antitrust work, all kinds of things. And you see that in a lot of bipartisan ways. There's some interesting work being done with Texas and Colorado right now on stuff that I don't have anything to do with, but where it makes sense for them to align. And so I do think that this is in particular an area where even if you've got different states passing different laws, we have a long history of working together. And I think that will continue, especially in this space.
Great. There was a question over there.
Yeah, just for the panel generally, let's say you are drafting a federal privacy law and you can choose to either start with the EU framework or the Colorado AI Act framework. Which are you going to start with? And let's say, assuming that, well, I've heard some people say that the EU seems like a better place to start. What would you have to change to get that passed at the federal level?
So Congress doesn't pass laws, but Congress also doesn't pass 144-page laws. If the GDPR, the General Data Protection Regulation, was not well written to be an export, the AI Act is really not well written to be an export. It's using institutions that we don't have in the United States. It's relying on a bunch of mechanisms we don't use because we're a country as opposed to a transnational organization of different countries. That said, there are some common backbones between the EU AI Act and the Colorado AI Act and other kinds of laws that we're seeing that I think are really interesting. I'm going to give you my greatest hits from the AI Act that I like, and then some things I think it's missing, the EU one. So one, I'm really intrigued by the concept of AI recalls, like the idea that if you put a system out there and something goes terribly wrong, we make you stop using it. That's something I think could get some purchase in the United States, because even if we're against the precautionary principle, once something's out there and it's causing harm, we might be able to get on board with recalling it. Some of the stuff around testing and having an understanding of where the data is coming from, checking for accuracy, et cetera. We see things like that appearing across jurisdictions as some sort of common sense measures. We also see it bubbling up in international standards setting organizations saying like, this is the way that's like the good practice to be a good AI developer. So that kind of thing too is a good core. And then on the consumer protection side of things, Stevie mentioned the one that's near and dear to my heart in the Colorado AI Act that the EU AI Act doesn't have, which is the right to appeal a consequential decision. So you don't have a right under the EU law to ask for reconsideration of an AI-made decision with serious effects. You do under the Colorado AI Act for now. So here's crossing fingers that those amendments don't get rid of it.
Fantastic. Yes.
I noticed in Calli's list of potentially harmful uses, we didn't see military applications. I want to ask to what extent we think those kinds of applications are driving AI development, and for our legal folks, do we foresee the need for laws along the lines of treaty law and arms control regimes?
Yeah, that's absolutely there, and that was a miss on the list. It was an incomplete list that I was writing very fast. You're absolutely right. There's already quite a lot of AI military application. There are systems that are designed specifically for military use and that are in use. The problem that my particular organization has in interacting with that is that there is so little transparency on even the existence of those systems that it's very hard to get any kind of information on accuracy, use models, how they're built, anything like that. And understandably, a lot of the justification for not sharing that is national security and military confidentiality issues. I understand that and don't necessarily think anyone's lying when they use those excuses, but it does make it very hard for there to be much knowledge about whether there is international conversation about what systems are going to be permitted or what are fully banned. Unfortunately, I'm worried that some of the military application is going to have to be in use, and then people will raise, hey, that violates the Geneva Convention or something along those lines. Those may be applications where something has to go horribly wrong before we see pushback. And I hope that's not the case, but I worry that's the case.
I have a quick amendment to that, which is that a former colleague of mine and co-author of mine, Rebecca Krutoff, who is at Richmond Law, writes on this. And some of the stuff she's written has been, so there was a conversation about killer robots, right? About like, should we have automated weapons in the sense that there's no human in the loop in making a decision about killing somebody? And there are different readings of international law. This is not my area of expertise, so I'm paraphrasing. But my understanding is that there's nothing explicitly in international treaties that says you cannot use a robot to make a decision. What there are principles that a use of an automated system might end up violating. So like a proportionality principle that says, this has to be tailored to have minimum civilian casualties might be violated by an automated system that makes a decision to use widespread use of force. So these conversations are happening, and we know about weapon systems that use them, but they're very much outside, as Calli was saying, the regulatory regimes that we're talking about here. Like even data privacy law has all kinds of carve-outs, and definitely the data privacy laws we have been discussing do not apply to the military.
Great. All right, I think we have time for one last question.
So my history is I build black boxes. I heard a reference to black boxes. My question is, by your definitions, when does my black box become an AI versus a spreadsheet with a if and in it?
Let's take that.
Give me a second, I can pull up the OECD definition. So I'm such a lawyer, right? Like there was a conversation around, and this is all part of the public meetings of the task force that Stevie referenced earlier, so I'm not giving anything away. There's a conversation around the Colorado AI Act that focused on, gosh, this definition of AI seems really broad. For me, my reaction to it is, do you want to write a different definition of AI from what everybody else in the world is using? Or do we want to use the one that has been arrived at as a consensus at the OECD? The limiting elements of a law like the Colorado AI Act are actually around what is a consequential decision. So it's not about, is your spreadsheet that puts out an output an AI system or not? It's, are you using, a computer generated output to do something that is really going to have big effects on somebody's life? So that's where we lawyers put in the narrowing part. It's not about the definition of the technology, it's about the definition of where the technology is applied.
And then just to add, I kind of know the OECD definition just from having to negotiate it so much. Even if your black box is not considered AI under the legal definition, if you're negotiating an agreement with a customer who has a broad definition, like the OECD definition, which is a machine system where you input data and have an output of content or text or data, very broad definition, then yes, maybe your black box could be considered AI when you're negotiating.
The only thing I'll add to that is we get this question a lot at our office, understandably. And it may be more comforting under some attorneys general, right? But we have discretion, like law enforcement has discretion action, and it's always a conversation. And so I think that the inclination, and I can say this confidently from our office, is not to be like, gotcha, you were using a spreadsheet and trying to hide that you were AI. It's really looking for, like, are you operating in good faith? Are you trying to do all? Did you listen to Shelby when she gave you advice? And they ran and deployed the system, no matter what it was, in a way that caused harm. And I think that's a lot more meaningful than, was it a spreadsheet or was it something more complicated? And oftentimes I think that like the level of computation to do something that we're thinking about are far beyond what a spreadsheet, at least what I could do with a spreadsheet, but what I imagine a spreadsheet can do.
Great. Well, I think we should leave it there, but I certainly learned a lot. I hope that you found this conversation to be informative, stimulating, thought-provoking, and more. So please join me in thanking our amazing